A trust is vastly different from a will. Let's talk about a will for a second. A will is only valid after a person dies. So if a will is created, you don't know whether it's valid until the moment of their death, because it doesn't come in front of anybody prior to that. A will has to be probated. It has to be proved, because you can't cross-examine the person who wrote it and said and ask them, "Did you really write this?" So it has to be proved, and that incorporates a court process. That court process is time-consuming, is expensive, and is all public. So 3 major flaws, if you will, of having only a will. Number 1, you'll have to pay probate fees. Probate fees are nailed into the California Probate Code. And on a $500,000 estate, they're sizable. On a $1 million estate, obviously, they're much more sizable. There is no reason in the world to pay those. They can be completely avoided by creating a revocable living trust, and that's what we do. So that's one, probate fees. That's one difference between a will and a trust. Second difference is confidentiality. Every document in the will, or every attachment, the will itself and all the attachments, they have to be probated. That has to go to a court. And it's filed with the court, and anybody can come and take a look at that court file. They give their driver's license as security to the court clerk, and then they can photograph it, they can copy it, and then they can take and sell that information to the highest bidder. You cannot do that with a revocable living trust. A trust is a private document. It doesn't go in front of if it's done right, it doesn't go in front of any judge. It's completely private. It's a family affair. It doesn't go outside. It stays confidential. For the most important assets of your life, you don't want them trotted out in front of everybody. That's the second one. And the third is the time. Courts these days in most metropolitan jurisdictions take 2 to 3, sometimes even 4 years to probate an estate. With a complete estate planning package, it's effective immediately, so that if you become disabled, all of the circumstances are spoken for in the estate plan. So there's no conservatorship. You avoid that whole court process. And then at the ultimate passing, when a person dies, you avoid the probate process. Nothing goes in front of a court the way we do a trust. Everything is plain. The distributions are clear. And the result, as I said, was peace of mind and a love letter to their families.